As to the directors, I do appreciate you coming in. I told council the other day that I didn't bring you here to in any way attempt to embarrass you or to yell at you. I'm not a congressman, this is not a congressional hearing. Though we've had this litigation ongoing since 2007. And since that time, I have seen very few of you participate in the court proceeding. And I wanted you here today to understand how these decisions are made. As directors of the EMC, you need to be fully engaged in this litigation. You hopefully have been fully engaged in this litigation, but you have not been in court, which raises the fear to me that everything you are hearing is second-hand, third-hand, fourth-hand. And while I am in no way suggesting what attorneys have told you is in any way not fully truthful or incorrect, that you are much better off as a director with a fiduciary duty to a member hearing it in court. So I am glad that you have answered my invitation to be here. Every one of you has become a director because you were successful in business and you were active in this community, whether it be church, whether it be a civic organization, you were very active. And that is why the members have made you directors. And I need you to remain active as directors who care about the EMC first and foremost, and who do not care about personalities on either sides of these issues. Now, we started in 2007. In 2008, you reached an agreement. You signed off on the agreement as directors. The agreement we reached would not have occurred if I didn't have a preliminary hearing on October 30th, if Sarah Brown hadn't sent a synopsis of the agreement to you that y'all agreed to. On December 3rd, I entered an order adopting your settlement. Not the attorney's settlement, but your settlement. And it provided that Cobb Energy, which was the for-profit company, would be folded back into EMC. This was the main thrust of the litigation. The plaintiffs essentially claimed that Cobb Energy was nothing more than a pork barrel project that atrophied, and that allowing preferential stock with an 8% dividend was no different than really an earmark for certain special people. And we resolved that issue. You resolved that issue by folding it back into Cobb Energy. We've done away with this adder tax on the members, and we've done away with these earmarks. And I'm using the congressional words because I want the visual of the way they portrayed it in the litigation. You want to continue with your advertising? Okay. But you resolved that. You came to the table and resolved that. And we did fold it back in. At the same time, you agreed to a liquidating trust to get rid of or close down these non-core businesses that Energy opened up that were losing money, never made money, or for whatever reason were started. We still have the liquidating trust, and I still get reports. They're rather vague, they don't tell me anything, and I think the best way to handle that is to suggest that Mr. Brown, Mr. Davis, and Mr. Carr, I would like to have a monthly meeting with the head of the liquidating trust, a board member, of course, counsel. Does the liquidating trust have its own counsel?
No, yeah, us, yeah.
Is there? Does King and Spalding handle that? Does
Yes.
Brock and Play handle that?
We'll get the right lawyers for it.
Okay. But I want a meeting with a board member, whoever's running the liquidating trust. Of course, somebody, Mr. Carr, or Mr. Dupree, and if you want to have one of the plaintiffs, so we can have a really discussion about what's going on. I want to have those meetings monthly. They can take place in my office early one morning. They're not in open court, and it's not the purpose to divulge proprietary information. It's just so that we all have a fully understanding why 2.5 years later certain things haven't been liquidated. And I assume there are very valid reasons.
There are.
And I'm not suggesting in any way they're not. But I want that meeting, and then once I'm comfortable that we're moving forward, we can maybe have it every other month. But we need to have that to make sure that we are on track. Do you have any problem with that, Mr. Carr?
Not at all, yeah.
Okay. So we need to do
That's
that.
a good idea.
We need to do that. The other issue is, and this is probably the more of the flashpoint than it deserves to be, is the issue of Dwight Brown. You reached an agreement that you signed off on that provided for over 2 years later that Mr. Brown would leave the EMC, that he wasn't going to leave it in December of 08, that he was going to leave it in February of 11. That gave you over 2 years to pick a successor. And it's hard for me as a judge to believe that Dwight Brown is the only person capable of running the EMC. There are probably 20 people in this room, including you 10 directors with your experience, who could run the EMC. Yet, the court had the feeling that, and I spelled it out in my order, that with the timeline, that it took you till the last day to come up with your corporate governance rules. And I find it difficult to believe that it took Rogers and Hart, who does this every day, 6 months to come up with corporate governance rules. It took approximately 10 months, or to March of 2010, to retain Russell Reynolds to search for candidates, and that we went all the way to the February deadline of when Mr. Brown was to retire to start really interviewing the 8 finalists, the 4 outside, the 4 inside. And then the members and the plaintiffs perceived an insult when you came back and that Mr. Brown retired but never left. And that he stayed in his office. He stayed with every authority he had prior to his retirement at the EMC drawing money. And I have never suggested that Mr. Brown was good or bad for the company. I will not suggest it today. But you reached an agreement in December of 2008 that gave you 2.5 years to replace him. And then you come back, and the date passes, he retires, and nothing changes. And you can't be surprised about the firestorm that caused. And it's not relevant whether you think he is the best person. The agreement the 10 of you, or Mr. Patel didn't sign off on but later endorsed, agreed was that it would be 2 years you would find a replacement. And the replacement, Mr. Nelson, was right under your nose. And I've heard nobody object to, on either side, to him being the replacement. But then we came, we had, we started off 6 months for this, 10 months for this. We had this dawdling that became a delay. And then you just knocked it off track by not doing it at all. And I think that was wrong for the members. But now we're back on track, and I think you were going to assure me that Mr. Brown is gone, correct?
Yes,
He's
sir.
gone? He's really gone?
Your Honor, as we have discussed in chambers, the board, after getting your order of June 24th, at its next regularly scheduled meeting, passed a resolution that all relationships with Mr. Brown, all employment relationships, consulting arrangements of any type were gone. And I believe you said you had earlier received calls about his car being there and everything. I assume that there have been no more calls because he has not been back on the premises since that resolution.
But the doggone delay and the derailing of his leaving just didn't sit right with anybody. And hopefully we're past that. And hopefully my order made that clear. However, just to make sure it is clear, I do want, when we have our meetings on the liquidating trust, I want to see the figures of what Mr. Brown was paid since the settlement agreement was reached, what he has been paid, and I mean directly or indirectly in any way, since February, the end of February, and what, if anything, he's received directly or indirectly to date, continuously. Now, I understand there are agreements out there that deal with possibly health insurance, pensions, and legal fees. And I'm not here to disrupt those agreements. I want to see what the monies are that's leaving EMC. And again, I'm not passing judgment on Dwight Brown. I was very happy when the criminal case did not come to me, although under the state uniform rules it probably should have. I was glad to give it up to our chief judge to deal with. But he was indicted. And you know, y'all talk about Delaware law, you talk about corporate governance. I contacted judges from Delaware and California to say, what do you do when an officer is indicted and the indictment alleges crimes involving the company? And I said, I understand that he's presumed innocent until proven guilty, and that he has to be proven guilty beyond a reasonable doubt by a jury. And I understand that completely, but what is the corporation's duty? And barring extraordinary circumstances, he should have been put on a leave of absence until that issue was resolved. It didn't happen. So I've said all I want to say about Dwight Brown. I want you to understand, I hope we move past it. I want to thank you for your years of service to the EMC, but we've got to go forward and resolve these issues and be done.